Welcome to our Married Trust Fast Track video featuring brief, condensed explanations and instructions designed to quickly guide you through signing your trust documents. If you need more, we offer separate videos with more expansive and detailed explanations and instructions for each of the documents and subjects covered in this video. You can decide what level of detail you want, now or later. Whichever path you choose, we strongly recommend that you sign your documents right away. Yes, you should also have your documents notarized as soon as possible. But no, you do not need to sign them in front of the notary. For notary acknowledgments, the law only requires you to present an acceptable ID and acknowledge that you signed the documents. If your notary doesn't know this, they don't know the law. To further aid you in executing your documents, you'll find that each one comes bundled separately with a cover sheet that also includes written instructions and illustrations. We suggest first organizing these bundles in a way that allows you to easily go to the particular document as it is covered. You should also pause this video as needed, signing each document before moving to the next. First up, we cover Article 1 of your trust, perhaps the most important of all because it contains the key clauses of the trust. Here, we will highlight the important parts of each page. Starting with page 1, it essentially states that you are declaring a trust while also setting forth the trust particulars, including the name and date of the trust and how title to assets should be held. Turning to page 2, you'll find the names of your children, and most importantly, your nomination of trustees. In other words, those who manage the trust. The separate issue of those who inherit is covered starting on the next page 3, which you'll see calls for the surviving spouse to inherit all assets at the first spouse's death. The next 2 pages, 4 and 5, specify who inherits after both spouses are deceased. Page 4 confirms the husband's wishes, and page 5 confirms the wife's wishes, both typically calling for the trust estate to be distributed to your descendants by right of representation, which means equally to your children if they all survive. You'll also find the young person's trust ages set forth on these pages. For those that are interested, page 6 contains instructions for specifying the distribution of certain household and personal effects. The next page 7 is the signature page, where each spouse should sign twice just above your respective names. This page also needs to be notarized, and when doing so, make sure the notary completes both acknowledgments. Next, we briefly discuss Exhibit A. In executing Article 1, you are also incorporating all the provisions of Exhibit A, which is a standard part of each trust containing all the other major articles of the trust. It consists entirely of numerous standard but necessary trust clauses, tax clauses, accounting clauses, potential subtrusts, and other supporting language. While many of these provisions and subtrusts may never apply to you, it is still important that they be there just in case they are needed, or the situation, circumstances, or directions call for them. While this standard language may be important and necessary to a comprehensive, adaptable, well-functioning trust, few will find it enticing reading. Yet trusts need this kind of language just as a car needs many parts and safety features. Yet it is unlikely that many find the shop manual or torque settings very interesting. The next document to sign is the Trust Estate, Master Transfer and Assignment of Assets, which is a general declaration that you presently assign and intend all of your assets to be a part of your trust. This document functions as an emergency backup in case you die with assets not titled in your trust. However, it should not be seen as a substitute for formally titling your assets in your trust, because enforcing it still means going to the expense and hassle of court, as well as an uncertain outcome. That is why it is always far better to title each asset in the trust while you are alive, something we cover thoroughly in a separate video entitled The Importance of Titling Your Assets in the Name of Your Trust. Be sure you have watched it. That said, please sign and date your master transfer document right away, then have it notarized as soon as possible. The next document to execute is the pour-over will, and for married couples, there is one for each spouse. The pour-over will is nothing more than an ordinary will that leaves everything to your trust. The main purpose of the pour-over will is to act as another backup device that allows your trust to gain control of any stray assets left outside of your trust in case nothing else works. The problem is that any assets which must pass through a pour-over will are subject to the probate process, the very thing you are trying to avoid. That is why it should never be viewed as a substitute for titling your assets in your trust. Unlike your other documents, your pour-over will should not be notarized. Rather, it needs to be witnessed and signed by two disinterested witnesses that are at least 18 years old. Be sure to carefully follow the included instructions, making sure to execute your will in front of both witnesses and that both witnesses sign and print their information where indicated just below their signature. The next document to execute is the certification of trust, whose purpose is to provide and certify the information needed by financial institutions when titling an account in your trust. Date and sign this document where indicated, have it notarized as soon as possible, then make copies to provide to financial institutions when requesting that your account be titled in your trust. The next document is the general durable power of attorney that grants your agent the ability to act for you on matters outside of the trust. For married couples, there is one for each spouse. Begin by turning to page 2 of the Power of Attorney. There you'll see the name of the person you are granting the power of attorney to, known as the agent. Towards the middle of page 2, you'll find a line for your agent to eventually sign, but don't need to worry about that now unless the person happens to be handy. For now, it's more important to get to page 5 where you should sign, then notarize the power of attorney. Also, on page 5, you have the option to limit this to a springing power of attorney by signing under paragraph 25. That way, it can only be used if you are incapacitated. The next document to execute is the Advance Healthcare Directive for designating healthcare agents and medical wishes. For married couples, there is one for each spouse. On page 1, you should print the name of the person you want to serve as your primary agent, usually your spouse. You can also optionally name up to 2 alternate agents, usually those who would be there to help or advocate for you at the hospital or in medical situations. Also, on the lower half of page 1, you'll find a line to sign confirming that your agent's authority starts now. We strongly suggest signing this line. Turning to page 3, please sign one and only one of the available options. Most choose either option A or option B. If you sign option A, you are essentially leaving all such decisions entirely up to the full discretion and judgment of your agent when you are unable. If you sign option B, which only applies if you are suffering from an irreversible end-stage terminal condition, then you are simply asking to be kept comfortable but otherwise refusing treatments that only serve to prolong dying and suffering. Turning to page 4, you should sign and date your directive where indicated, then have it notarized as soon as possible. Moving on, most married couples will also find a community property agreement, but only if it was requested. The purpose of this document is to help a surviving spouse secure the highly generous tax benefit of a full stepped-up basis available to community property assets. However, we again reiterate that you should only sign this if you are fully comfortable agreeing that all of your assets are community property. If you have any doubts or possible issues of separate property, you are advised not to sign this document. Otherwise, if you are comfortable, sign your community property agreement, then have it notarized as soon as possible. For those of you with minor children, you'll also find a nomination of guardianship for minor children, which you should sign and have it notarized. Other documents to execute often include quitclaim deeds or other deeds for transferring your real estate properties to your trust. Typically, a separate deed is included for each real estate property that you own, assuming you requested it. You should sign all deeds right away, then have them notarized as soon as possible. Along with each California property deed, you'll also find a preliminary change of ownership report, which you should sign on the second page near the bottom. Then, keep it together with the corresponding deed to include when you submit the deed for recording. This document is for informing the assessor that it is a transfer to a revocable trust and thus exempt from reassessment of property taxes. Please do not attempt to fill out any other information on the form. In some cases, you may also find a documentary transfer tax affidavit informing the county that the transfer is exempt from the documentary transfer tax. Only a handful of California counties require this form, so you'll only find it included if the property lies within such a county. If so, be sure to sign where indicated. Then keep it together with the corresponding deed to include with the deed when recording it. Once signed and notarized, each deed should be recorded at the county recorder in the county where the property sits. First, determine the correct recording fees and mailing address by consulting the website of the applicable county recorder. If the property is outside of California, you should also determine if any forms need to be submitted with the deed. Next, address a full-size envelope with sufficient postage large enough to hold your documents without folding them. In the envelope place, the original deed, not a copy, including any Exhibit A, if any, a check to cover the recording fees, the corresponding signed preliminary change of ownership for California deeds, any documentary transfer tax affidavit, if the property is in one of the few California counties that requires it. This concludes our fast-track video for married trusts. Remember, you can always watch our other great videos that go into greater detail. Yet, if this fast-track video helped you finish executing your documents, then congratulations. You've taken important steps toward protecting your family and estate.